Good afternoon. Our next case is Cullen versus Logan Developers, Inc., and we'll hear from the appellant.
May it please the court, Jeff Stoddard, I'm here with my colleague Walt Rapp on behalf of Logan Developers Incorporated. I would like to reserve 5 minutes for rebuttal, and I want to begin by saying it's an absolute honor to be before you today. The question for this court is whether the lower courts, in particular the Court of Appeals in this case, are following this honorable court's ruling in the Drohan case that was decided in 2020. In particular, what this court is going to be asked to discuss and examine are the rules on contributory negligence, summary judgment, and gross negligence. And we're going to begin by discussing contributory negligence in particular. And we start that way because if one were baking a contributory negligence cake, this case would have all the ingredients. The facts of the case are really quite simple. Plaintiff, by her own admission, her own words, was walking backwards in an attic, an area where she knew she could not step off the catwalk. She was distracted by taking photographs of where she wanted to add more subflooring. This demonstrating it's a dangerous area where you need to be careful where you're walking. She stepped backwards and stepped into what is called a scuttle hole. And we'll talk about that at some length today, but it's a hole required by the North Carolina Building Code. The reason plaintiff fell through that scuttle hole is because she was distracted by a method of her own choosing. She was taking photographs instead of looking where she was walking. Decades and really now in excess of a century of jurisprudence from this court say and provide and have, in our opinion, clearly instructed the lower courts constitutes contributory negligence. The trial court in this case, with a very considered order, specifically noted that exact fact and came to that conclusion. The trial court's order specifically noted that plaintiff had the opportunity to step backwards, had the opportunity to look where she was stepping and didn't do so. And so when we're asked to examine what constitutes contributory negligence, the case law in this court is clear. The question is not whether a plaintiff would have seen it, but whether whether a person using ordinary care for his or her own safety under similar circumstances, and this is the part that really matters in this case, would have looked down at the floor. That's the turning linchpin of this case. The Court of Appeals most respectfully misunderstood that nuance. The Court of Appeals said that this case was about whether plaintiff knew of the existence of the scuttle hole, whether and to what extent it had been concealed. But that's not what this case is about, because plaintiff specifically testified if she had looked behind her or down, she would have seen the insulation in the scuttle hole and she would not have stepped there. This is again particularly true in the setting of an attic, which is a much more dangerous place than one's living room or one's bedroom. One of the arguments that we've heard from the Appellee's counsel in this case is that, the plaintiff had an entitlement to this hallway, and I believe it's page 247 of the record on appeal, and it's in the first few pages of our brief, and it's helpful to look at. You can see that this is a very narrow catwalk in an area where there are numerous hazards that one should be mindful of where they're looking while they're walking. And what the Court of Appeals seems to have not applied is the analysis of the 2020 Drohan decision that I mentioned a minute ago. In the Drohan decision, a gentleman was carrying a casket down a flight of steps and unfortunately tripped, or now I can't remember whether it was up the steps or down the steps, but either way, tripped on the top step, which was of a different height and a different material. One of the most important quotes from that decision, however, is this. And the Court of Appeals, the Supreme Court ruled that a reasonable person would have looked down. And plaintiff in that case admitted that he was not looking down, he was looking at the door to the church. And that's almost precisely what we have in this case. Appellee's counsel has tried to distinguish that case on it being an invitee situation or warning of an open and obvious danger, but that exact quote from that decision is that a reasonable person would have looked down. And in that case, Justice Earls wrote a very eloquent, thoughtful, and lengthy dissent. And if you apply the logic and the quotes from Justice Earls' dissent to this case, you still result in a contributory negligence finding. Justice Earls noted in particular, and I'm sure you'll correct me if I'm wrong, that Mr. Drohan had claimed and created an issue of fact that what he tripped on was not perceptible to the naked eye, and that he had been lulled into expecting stair uniformity. Plaintiff and Drohan even disclosed a human factors engineering expert who was prepared to offer that same opinion and had filed an affidavit to that effect. Here, plaintiff cannot rely on that same factual distinction that Mr. Drohan had. Again, I've said this before, it's contained in the brief, and you're probably tired of me saying it today, but it's so crucial. Plaintiff admitted that if she had looked while she was stepping backwards, she would have seen the hole and she would not have stepped in it. And to Justice Earl's point in that case, an objective, reasonable person when walking up and down stairs may not need to look at every step. You know, most stairs are in fact uniform. But an objective, reasonable person in an attic where there's danger and hazards everywhere. There's the trusses that are in the way, there's mechanical air handlers that are in the way. One needs to be mindful of where they're stepping and not be distracted by taking photographs.
So one argument I think your friends are going to make is that you're stating that like it's sort of axiomatic, but really it's a question of reasonableness. We think of reasonableness as a question of fact. So whether that's true that a person using ordinary care, reasonably prudent person would never walk backwards in an attic, they would always look before taking a step back, is something that a jury of 12 people needs to get together and think about. It's too hard for the court to answer that. But I guess your position is that can't be right because look at past decisions.
That's exactly it, Your Honor, and that's exactly where my outline transitions to next, which is that the decisions of this court, if you compare the appellant's brief with the appellee's brief, you will see that the contributory negligence decisions we have cited were all authored by the Supreme Court, with the exception of the Seeley decision, which was issued by the exact same panel of the Court of Appeals, but we'll get to that in a minute. As Justice Barringer pointed out in an argument earlier this morning, the appellee's brief cites two Court of Appeals decisions which are not binding on this court. But what's crucial about distinguishing the cases that found contributory negligence as a matter of law and ones that didn't are all about this unexercised opportunity by plaintiff to avoid the accident at issue. So we have the Lee versus Carolina upholstery case where a gentleman is loading appliances into a car and or a truck, he's using rope. The rope slips out of his hands and he steps 3 or 4 feet backwards and falls into an elevator shaft. And the court there held that it was a method of his own choosing. In Swinson versus Lejeune Motor Corp, a plaintiff was eye-searching the parking lot looking for a car, inattentive to where she was walking. She had the opportunity to see the hole and didn't exercise that opportunity. Dunavant, this is the case that allows me to say centuries because I think it's 1914. A gentleman became familiar with a railroad platform during the day and then at nighttime walked off without a lantern and tripped and fell. He had the unexercised opportunity to bring that lantern, which would have illuminated it and prevented his fall. The Holland case, a mechanic tripped on garage equipment where he would have expected equipment to be there. The Walsey case, a plaintiff stepped in a meter box in front of her home because she was distracted by a barking dog. Walsey's a little unique because, and maybe not exactly on point, because she had complained to the water company about that water box. But what's useful about all of those decisions is that they have plaintiffs, and again, these were all plaintiffs who were barred as a matter of law, who had an unexercised opportunity to avoid the very accident. And Mrs. Cullen's own words in this case suggest the same thing just as those other plaintiffs. Her admission in her deposition testimony, nothing obstructed her view of this hole. And that's what is the distinction between the cases that the appellees cite. They cite the Manis case where a construction worker fell through a hole because there was a hole in the concrete and plywood placed over it. And the Duval case, I think, is the most instructive. A plaintiff there was leaving a hotel and the lights had gone out, complete pitch dark. She's holding on to her husband as she descends the stairs. Her husband has a walking stick feeling for the stairs. She's holding on to the railing with her other hand, and she falls. And the Court of Appeals, I think, correctly found no contributory negligence as a matter of law in that case. Well, what's different about those cases is that there wasn't an opportunity for those plaintiffs to avoid the problem that befell them. In Duval, the plaintiff is leaving a hotel. She has nowhere else to go. The plaintiff here is taking photographs of where she wants to add more subflooring. There are numerous ways in which she might be able to do that in a much, much safer manner. And I think the better line in the sand is one of unexercised opportunity, because plaintiff in this case has clearly admitted to the unexercised opportunity to look down, which would have prevented her fall. This kind of, actually, one other point I wanted to make about these other cases is, if you turn to the Drohan case, the Supreme Court in that case cited the older Coleman and Garner cases. And all those cases boiled down, distilled to one principle. And that principle is people need to watch where they're going. People need to watch where they're stepping to look out for their own safety. And now that doesn't mean that you have to never look up. But in this case, plaintiff admitted she had the view of the entire walkway, and that if she had looked, she would have avoided the accident. This turns us to the way in which plaintiff might be able to avoid a contributory negligence finding, which is if the defendants are found grossly negligent. The Court of Appeals decision in this case seemingly overturns a prior Court of Appeals case that has been on the books for a long time called Bashford v. North Carolina General Licensing Board. And that case stands for the proposition that a mere violation of a building code is not sufficient to prove gross negligence. Plaintiff in this case is arguing that the scuttle hole and the work done by Logan developers constitute a violation of the building code. So as a factual matter, breaking down what happened with this scuttle hole. Scuttle hole is a hole between the regular living floor of the house and the attic. And through that scuttle hole is where HVAC workers are supposed to be able to put mechanical air handlers and other attic appliances. The building code provision is designed to protect HVAC workers from not having to carry this heavy equipment more than, I think it's 20 feet across a catwalk where they can't raise up. So this building code provision is not about protecting homeowners such as plaintiff, it's about protecting HVAC workers from their injuries on the job. So this scuttle hole was installed by Logan developers at the requirement of the Brunswick County Building Inspector's Office. The scuttle hole was seen by plaintiffs, and there is a little bit of a factual issue on this, but I don't think it's one that's genuine to the determination of this case, is that the manager for Logan Homes said that the Cullens declared the picture frame, the hole in their bathroom where the scuttle hole was, as an eyesore. Plaintiffs denied that was the case. Of course, that begs the question why Logan Homes would take on the unnecessary time and expense of covering up the scuttle hole. But what they did was they removed the picture frame and then taped the piece of drywall that had been cut out for the scuttle hole and painted over it so that it would look like one sheet of plywood. This had no bearing on what the attic side of the scuttle hole looked like. That's the crucial factor in this case. Even if that was a building code violation, the fact of the matter is that hole should have remained open. That's what the building code requires. So if plaintiff had their way, they'd be arguing that that hole should have been closed in violation of the building code. And one of the things that the defense, and the appellants in this case, have struggled with throughout this case is how a developer or contractor is supposed to be put into a position where leaving the scuttle hole open is gross negligence as to the plaintiff, and closing the scuttle, or excuse me, and then closing the scuttle hole is gross negligence as to the HVAC worker who has to go up there. And the key distinction, I think, that should guide this is, what does it mean to be grossly negligent? And the case law is clear on that. We're looking for willful and wanton conduct. We're looking for this conduct that reaches an extra level, not just negligence. So negligence questions in this case are, should that scuttle hole have been covered? Should there have been yellow paint around it? Should the homeowners have been warned more clearly? Those all fall into the category of negligence. They don't meet the necessary requirements for a finding of gross negligence. Gross negligence requires the conscious and reckless disregard for the rights and safety of others. And in this case, leaving the top of that scuttle hole open, the testimony is clear, it's not contradicted, leaving that scuttle hole open was because of the regard for the safety of the HVAC workers. It is, of course, highly unfortunate that plaintiff fell through this scuttle hole, but this was not a hole that was created because of a conscious and intentional and reckless disregard to the plaintiff. It was created because the building inspector required this hole. And so the appellees and plaintiffs have argued in this case that Logan developers in their own homes would not have left this open, they would have covered it, or that they could have put something else up around it. Again, those are questions of negligence, they're not questions of gross negligence. In particular, on the employee who testified he wouldn't leave the hole open at his own home, he specifically testified that he could do that on his own home because the building code didn't apply to him there. The building code applies to him in his job when he has to protect the HVAC worker that way. If in his own home, somewhere down the line, an HVAC worker goes up there and injures themselves, he may be liable to that HVAC worker who gets hurt, but it won't be because of the building code. There's also been an argument that the OSHA standards should be used to establish gross negligence because there was no railing or other warning around this hole. OSHA standards are, again, used for the protection of workers, not for the home employees. That's who the statute is designed to protect. The distinction for this, or the important thing to add to this, and I am citing Court of Appeals decision, and it's the Autry versus Bill Clark Holmes case, but I think it's instructive and persuasive for a couple reasons. And the first is that in that case, the Court of Appeals said that the intentional disregard and indifference to regulations isn't what mattered. It's the intentional and, it is the intentional and indifference to rights and safety that's what matters. And so leaving that hole open may have been an intent, or closing that hole on the bathroom side for cosmetic reasons may have been an intentional violation of the building code. It wasn't one done because of this deliberate misconduct, this conscious and reckless disregard as to the plaintiffs. And maybe the biggest overarching problem with the Court of Appeals decision in this case is that that opinion is already being cited in arguments, in briefs. They're available on Westlaw for extremely broad opinions. Or for extremely broad arguments, that contributory negligence is essentially never available in, summary judgment is essentially never available in contributory negligence cases. And a finding for plaintiff appellees in this case, I think sends that message not just in contributory negligence cases, but all negligence cases where assumption of the risk or open and obvious is at issue. If Rule 56 no longer applies in all those cases, it has been effectively removed from the rules of civil procedure. I think that's an extremely broad result that shouldn't be the case, that doesn't seem to be the case based on my reading of the Supreme Court opinions, and it's one that the Court of Appeals opinion in this case is being relied on to argue. If there are no further questions, and I'm happy to answer any you have, we'd rest on our brief and reserve the rest of the time for rebuttal.
I do have one question. I want to go back to your argument about contributory negligence and the contention that if there's an unexercised opportunity to prevent here the fall, but to prevent the injury or the accident, then that's, as a matter of law, contributory negligence. Isn't there the danger that that approach essentially creates contributory negligence in every possible case? I mean, here you could say, even if, and I understand here the argument is that she should have looked down, that she had the opportunity to look down. But even if she, you could argue that she shouldn't have been the person to go up in the attic to take the pictures in the first place, and that would have been an opportunity to prevent the fall. And I think in any accident situation, you can hypothesize that the injured person could have done something differently that would have prevented the accident. Whether it was not get up out of bed that morning, or I mean, you can. And so, isn't the constraining factor here that it's a question of reasonableness, and why isn't that for the jury to decide?
Justice Earls, that's a great question, and one that is essentially set out in your dissent in the Drohan case. And I have two responses to it. The first is that this case is different from Drohan in that she admits if she had looked down, she would have seen the insulation, she would not have stepped there, and she would not have fallen. That is much different from Mr. Drohan, who said, hey, I wouldn't have seen it. And that's a factual issue that a jury should decide. But in this case, her own testimony is, nothing obstructed my view, and if I had looked down, I would have seen it. All of the Supreme Court case law cited in my brief says that if you weren't obstructed by some external force, if her husband had bumped into her and that's why she didn't see it, if she was loading a box and that's why she didn't see it, things that are reasonable to do in the attic, if her husband are walking past each other on the catwalk, that becomes a different case. The second reason I think there's an important distinction here is that she was in an attic. She was not in her bedroom, she was not in her living room. This court, I'm not asking this court to declare that walking backwards without looking is always contributory negligence as a matter of law. I'm asking this court to make that determination based on these facts. If plaintiff had fallen in her living room, I would not be able to argue that it's always contributory negligence to walk backwards in your living room.
Thank you.
Any other questions that I can answer?
Thank you, counsel.
Thank you, Your Honor.
We'll hear from the appellee.
May it please the court. Chief Justice, Associate Justices, I am Meredith Hinton, and Will Patterson and I represent Deborah Cullen. The decision of the Court of Appeals should be affirmed as this case involves genuine issues of material fact that precludes a finding of contributory negligence as a matter of law, and this case should be decided by a jury. The Supreme Court has long held that summary judgment is rarely appropriate in negligence actions because ordinarily it is the duty of the jury to apply the standard of care of a reasonably prudent person. Mr. Stoddard argued in his brief that the Court of Appeals relied on a different standard for summary judgment, and that standard was inconsistent with I'm not sure how to say this, I've been saying drawn, so forgive me if I'm saying it wrong. But essentially he's arguing that the drawn case created this different standard. And I think it's important that we look at the language. So language says that courts should hesitate. Hesitate. Synonyms for hesitate: reluctant, unwilling, disinclined. He wants you to believe that this is a far cry from the long-held standard in language that summary judgment is rarely appropriate. It's not.
Yeah, and I know there's been quite a bit of discussion about what all those words mean, and what bothers me a little bit is I think all of that discussion is just sort of like editorializing what the summary judgment standard really is, because there's no hesitancy that we apply. The standard is so straightforward. It's the question of law, so it's de novo review, and we're just asking, was there a genuine issue of material fact or not? I don't know why we would hesitate one way or the other when deciding a legal question. So it seems to me your much stronger argument is just, this is a question of reasonableness. 12 jurors are going to decide, given the situation, the familiarity with the attic, is it a breach of, what an ordinary person would consider due care to walk backwards and fall into the hole and so on. And I guess, so my question to you is, and I don't know how to pronounce the case either, but
Okay.
But how do you, if that's, because I think that is your position, and how do you square that then with the outcome in that case? Because I could make the exact same argument saying 12 ordinary people may think that you don't always have to look down when you're carrying something heavy and walking. You can kind of feel with your feet or do various other things. So, but it seems like the court did decide that as a matter of law. So how do those two fit together?
And so are you just talking specifically about the drawn case?
Well,
and how does our case
I'm saying if we accept what you're arguing here about why we can't rule as a matter of law, wouldn't that mean if you went back and took that same holding that the outcome of that case should have been different?
No, sir, absolutely not. as Justice Newby talks in the drawn case, it's each case should be decided on their own merits and the facts of each particular case. Our case is very different from the drawn case, and I can go ahead, and that kind of leads me into my next, points here, is this case has a ton of disputed material facts. I think just, starting out, did Mrs. Cullen even know what a scuttle hole was? She testified, she didn't really know what it was. They asked her questions after the fact and what she knew after the fact. But her husband testified the first time they'd ever heard scuttle hole was when this litigation started. I'll be honest, I didn't know what a scuttle hole was until this litigation started and we had to figure all this stuff out. So to then imply that, okay, there's a question of fact of does she know what a scuttle hole is? Okay. Another question of fact, does she know when she looks and sees that frame that there's actually a hole in her attic? I don't know. When you're at your house, do you know if you look up at the ceiling where that goes up to your attic or to your next floor? I think that's a question of fact for the jury to hear. Then, even if you take that a step further, does she know that looking at that frame, even if you say, yes, she knows it goes in the attic, well, does she know that it's a hole in the floored walkway that was there when she went up there the time before? I think that's, again, a question for the jury to hear, question of fact. Does she ever even know that they cut a hole in the framed walkway? Question of fact. And it also goes to credibility. Do you believe the Cullens or do you believe Logan developers? And we all know credibility issues are to be decided by a jury. There's so many different facts. Mr. Stoddard mentioned multiple times in his brief and his arguments with you today that she's walking backwards. Mrs. Cullen never says, I was walking backwards. She testifies, I think, 3 or 4 different times in her deposition that she doesn't remember what happened, that she and her husband have talked about it, and that's the only thing they can think is maybe she stepped back and fell through the hole. That's how they figured that out based on the way she landed on the vanity and then on the floor.
Do you agree that most folks appreciate that where there's insulation in an attic, you're not supposed to step in it?
Absolutely, and that I can address that point for you, Justice Newby. I think her testimony is, Walt asked her, well, do you know that if there's insulation, you shouldn't step on that, right? Of course, she's going to say, no, I shouldn't step on that. I know that. But I think the thing that they're glancing over when they're just pulling out that one little quote is the fact that when she walks in that attic, she knows that the floor that is made for people to walk on is in the shape of an F, capital F. She knows this. It was like that the first time she went up there. She knows that the roof trusses are designed so that there's trusses on this side, there's trusses on that side, there's blown insulation on both sides. So yes, she knows she can't step to the right off of that F as she's walking in, or step to the left. Of course, she knows that. But this is part of the floored walkway. And in her testimony, she testified that as she's walking in, she did not see the insulation in that hole. And I think there's wherein lies the difference on the drawn case is, as she's walking, she's looking like a normal person. Does she see it or does she not? That's a question for the jury.
Well, isn't the real question, did she know if she stepped off the catwalk or the floored area that that would submit herself to a danger?
Well, I think the difference here is that this was part of the catwalk before. Where this hole was created, it was cut into the catwalk. She did not know there was a hole in this catwalk. In the drawn case, we have a clear picture, right? It's in the opinion. Everybody can see it. as you're walking towards it, everyone can see it's out in the open, it's stairs on the exterior of this church. In this particular case, we don't have a picture of what the attic and what that insulation and what the floor would have looked like for Ms. Cullen as she saw it that day.
But we do have her testimony in the deposition where she says, if I had looked down, I would have seen that there was insulation there and I wouldn't have stepped on it. So why isn't that ultimately dispositive on the question of whether or not she, was contributory negligent here?
Because as she's walking towards this area, it's concealed. And it goes to the reasonableness that Justice Dietz mentioned. Is it reasonable for her to be able to walk on the safe passageway that she's always walked on? She doesn't see this area.
But
It's a low contrast. Our expert talks about that. It's low contrast. It's also, if you look in the pictures and in the expert's report, he talks about that it's bat insulation. And so this is different insulation than what is seen in the blown insulation that you can see in the pictures, which raises up. This insulation is bat insulation, so it would be flush with that hole. So that is a concealing, that's concealing to the eye. I think in the Drawn case, and again, that's, a Supreme Court case that I definitely want to address. In the Drawn case, Justice Newby talks about there's different things that gave warning, okay? So in that case, the plaintiff had actually gone up the stairs before. He had walked up the stairs, had the chance to appreciate it. It's also noted that there was a distinct height difference. That last stair was 4 inches higher. Here, we've got bad insulation, which would have been flush with the flooring.
It seems like you're perhaps trying to use a bad turn of phrase, maybe in this context, step away from your client's testimony. If your client said, and it's my understanding during her deposition, that had she looked, she would have seen the hole. How does the fact that even if we accept that there was a different kind of insulation used, what does that matter? Your client has said, yeah, had I looked, I would have seen it. It seems like you're trying to argue that there are reasons why perhaps she wouldn't have seen it, but she said she would have seen it had she looked.
Well, let me just go back to, there was a question in her deposition. This is on page 433. And as you approach this area, you would have been able to see insulation and not plywood in this hole, correct? She said, I did not see that at all as I was walking. So I think that's a question for the jury. She's saying she didn't see it. So is the concealed nature of it because it's flush with the flooring, does that, give reason for her? I mean, is that a reasonable thing that she didn't see that? Also,
Well, but did she intentionally step in it, or did she step backwards into it?
she stepped backwards.
So she didn't intentionally step in it. She didn't rely on, okay, it's flush, so I'm going to try this out. She didn't do that.
No, sir. No, sir, she did not. She, like I said, she's walking down the F part of the walk, going up the F, and this is the bottom rung of the F where she stepped backwards.
How many times has she been in the attic previously?
She believes she was in there twice before, but not when the hole was created. And also, I think, going to reasonableness and what she should have seen, could have seen, also, when she's walking in this safe walkway, if you look in the pictures, there's storage boxes on the other side of where this hole was. So I think it's a question of, was that reasonable that she would think that the floor is like it was every time she'd been there before? And that was her testimony, that, she had no reason to believe. And we all know the law says you have no duty to anticipate the negligence of others. We're not here to argue about Logan's initial negligence. That's not part of the appeal. But she had no reason to anticipate that they would cut this hole and leave this unmarked, dangerous situation that even they testified is a safety hazard. They testified that, yes, this is a safety hazard, creating this hole in a walkway.
So my understanding, so your client said, I couldn't see, when I looked over there, I did not see a lump of insulation standing up from where the sort of plywood walkway ends. And because of that testimony, when she later says, they ask, you know, if you had looked, you would have seen the hole. She says, if I had, I would have seen insulation and I would not have stepped in it. Your argument is, so the inference there is, but she couldn't see it anyway. It was not something that when you're just glancing at it, you would see a difference between the plywood and the insulation. Is that what you're saying?
Well, I
So
think-
she wouldn't have seen it anyway?
I think that is one argument, yes, that as she's walking there, she doesn't see it. And that's what she testified to. And then just to read this, she says, so there's nothing that would have prevented you from seeing the insulation sitting on top of the drywall. And again, that's sitting on top of the drywall, but flush with the plywood flooring. There was insulation, I guess, in there, but I did not look there because I knew I had this walkway. She knew she had that walkway. She'd been on it before. She had no reason to believe that all of a sudden there would be insulation in the walkway. There's nothing to cue her to that. She saw the storage boxes over there on the walkway. This was a walkway that had been there the whole time. It's, they talk about in their, in the deposition of, I believe it was Mr. Pender, that these roof trusses were engineered. So this is a walkway that was planned.
Didn't she know that they had, she knew obviously that a hole had been cut in the master bathroom ceiling, right?
Correct.
And she knew that above the master bathroom was the attic.
I think you can assume that, yes.
So that's why I'm struggling with the idea that she wouldn't have had any reason to suspect that there would have been a hole
Well, I think
in the attic.
the issue there would be, there's only this F that has the walkway, right? Capital F that has the walkway. There's all kinds of other attic space up there. So looking in her master bath, does she look up and say, oh, they must have put a hole in the walkway? I think that's a step too far. And I think essentially that's a disputed fact that a jury could say, hey, I believe Ms. Cullen had no idea that they cut a hole in her walkway. If she knew they cut a hole in her walkway, then I think that takes it in a different area, but she testifies she doesn't know. She never knew. And then if you even if you believe she knew they cut a hole in the walkway, based on Logan Developers' own statements, they imply that everything was fixed. His statement to the Cullens is, by closing, you'll never know anything was there. You'll never know this was there.
Can I ask you a follow-up question to Justice Dietz's question about this statement where she's asked if you'd look to the right instead of taking a picture to the left? So I'm looking at this and want to take any inference in favor of the non-moving party, but to the extent there are inferences to be drawn about whether she saw it, I understand what you're saying. On this fact that she wasn't looking down, what's the inference? Help me, what's the inference to be drawn in your client's favor on that? On the undisputed, she admitted I wasn't looking down fact.
I don't think she said I wasn't looking down. Her testimony was I didn't see it as she's walking there. But then she does state when she stepped back, she did not look down because she knew that floor was already there. And when she talked about she wouldn't step to the right or left, that's when Mr. Rapp was asking her about the other sections, like off of the floored plywood area. That's in the section where the roof trusses are, and you can see the pluming insulation.
But there's no dispute that she wasn't, or at least, well, maybe there is, maybe from your oral argument about what she actually remembered, but in her deposition, she didn't appear to be fighting the fact that she was taking pictures and not looking down. Am I missing something there?
Well, I think you're looking at that statement as like kind of in a small vacuum. She doesn't say I wasn't looking down or I wasn't paying attention to where I was walking. She walks in there and then stops, and she's trying to take a picture to her left. And there's the floored walkway that had always been there, what she thought was right behind her, and she took one step back to take the picture. That's when she fell. So I think it's different than, hey, I never looked down. I mean, she's walking, she's being careful, she was being safe, she never saw this concealed hole, and then she goes to an area and stops where she knows I'm on the safe walkway. There's no like roof trusses behind me. This is a safe passageway. There's nothing that would have given her any kind of cue that, hey, it's not safe to take one little step back. And I don't know that we want to make that law in North Carolina that you're contributory negligent is a matter of law if you take a step backwards. I mean, if you think about all the times in your daily life where you take a step backwards without looking, I mean, that happens all the time.
Can I ask you about, well, so you would agree, no matter what we do with contributory negligence, it won't impact the gross negligence claim. Do you agree with that? Because gross negligence, you can't make a contributory negligence defense to a gross negligence claim. Do you agree with that?
So, okay, say that again.
So, if in a gross negligence claim, can you claim contributory negligence to defeat the gross negligence claim?
They would have to claim that she was gross
Right.
contributory negligence.
So, which we're not talking about right now.
Right.
So I want to turn to that because it sounds like everything we're talking about right now is not going to impact that claim. One thing that confused me about the Court of Appeals decision is that they, I think it's the Rule 30b-6 deposition that they quote in the opinion where the deponent says, essentially, yes, I knew it was a code violation. The company knew it was a code violation. And then the Court of Appeals says, so that shows that it was a building code violation. And then they say, and it also shows that they knew they were concealing a hazard. And it didn't seem to me that last point flowed naturally from the 30b-6 deposition. So what is your evidence that the defendant knew it was a hazard to have that hole there to your client or anyone else?
Their own testimony. They testified that, I think the quote is, that poses a safety issue, it being in the middle of the floor. That was their own testimony, that it posed a safety issue. And then to take it a step further, they said, if it was my house, I would have covered it. And if you look at our expert report, I mean, there's very, very inexpensive things that they could have done, and we would never have been here. They could have put, I think our expert talks about putting a lip around it that would have given her a warning had she stepped back or stepped forward where she would have hit, something to prevent her from going. Just as if you go to the left and right, you're going to hit roof trusses. If they would have done that, it would have given her a warning. They could have, I think there was another argument, you could put a railing around it. You could put a hinge on a piece of plywood that would come up and down and prevented this whole thing. So for the gross negligence, I don't think the Court of Appeals is saying that just because they violated the building code that's automatically gross negligence. It's consistent with the other case law out there that, it's not just the violation of the building code, but it's the other things that go along with it. And in this case, our argument is that they willfully, with conscious disregard for the safety of others, left this concealed hazard in a floored walkway where the plaintiff had been before and knew the design of it, knew that there was flooring there. They left that concealed hazard.
I just want to make sure that I understand what you mean when you say concealed. I understand it was concealed, from the perspective of the master bathroom, all right. But in the attic, the hole wasn't, are you saying the hole there was concealed?
Correct. The bat insulation that you can see in the pictures, it's different than blown insulation. That was cut and then placed down in the hole. And we don't know if that bat insulation, and if you look online, you can see bat insulation put in different ways. Sometimes the cardboard is facing out, sometimes the insulation is facing out. We don't know. So I think that goes back to, this is an issue that a jury could look at and say that she was acting reasonable under like or similar circumstances.
But this is about the gross negligence, so it's,
Yeah, sorry.
it's about the developer. So just so I understand, you're essentially arguing that it was gross negligence because they used a different color insulation than what was around the walkway, and that it was level with the walkway.
I think on top of leaving by doing that, they make it a concealed hazard that's not going to be readily apparent to anyone in the attic. It's a danger that they knew of, but Mrs. Cullen didn't.
So I don't want to be guilty of running the contrib and the gross together either, but so I'm just trying to put all this together. So I'm trying to square what you just said with your client's admission that had she looked down, she would have seen it.
I mean, I think it still goes back to, as she's walking, she says, I didn't see this. She's saying, and then she says in her own testimony, she says there was insulation in there, I guess. She doesn't know what was in there, what was there to be seen. We don't know what was there to be seen. Unlike the drawn case, we don't have a picture. The drawn case has distinct things that everyone can see. This is more akin to the Land v. Bissett Realty case where it's not readily apparent. And I think a jury could reasonably believe that she didn't see this. She didn't see it, and the case law even talks about, it's not whether a reasonably prudent person would have seen the hazard, or she looked, but whether the person using ordinary care for his or her own safety under similar circumstances would have looked down on the ground where the hazard existed. I think a jury could think it's reasonable that she'd been up there before, she was in an area where she knew was safe, she had all the indications that that area was still safe. You see the storage boxes over here on the other side of it. There's nothing that would have given her any indication that that particular part of the plywood was cut out. In her mind, and I think a jury could believe this, in her mind, that she knew it was safe. All she did was take one step back and fell in this hazard that was created by the defendants. I hope I answered your question.
I think what you're saying is she did like a preliminary scan, didn't see anything, and so had no reason to believe that stepping backwards would have led to the fall.
Right, and I think, as we walk, yeah, we're scanning. Just like you said, we're scanning. The law doesn't say you got to walk and look down the whole time. That's not what our law says. Our law talks about, because if you're looking down and walking and you get hit in the head by something, you're contrived then. You have to walk and look at all of the surroundings. And that's what she did. She was looking, walking, looking at all the surroundings, didn't see anything. So, and I've got, and just to, I guess, go back to the gross negligence, we feel that a jury could find on these facts of creating this hazard in the walkway, that a jury could find that that was done in reckless disregard for the safety of others. In closing, I think, we've gone through all the facts. I think there is a genuine issue of material fact, and this case should be decided by a jury. Again, if Ms. Cullen would have said, I guess the argument is, okay, she said, yeah, if I saw it was insulation, I wouldn't have stepped on it. I mean, I don't know how she could have answered that any other way. Sure, she knows in an attic you don't step on insulation. But then if you look at all her other statements, she didn't know that there was insulation in the walkway. This is a walkway, a safe walkway. She had been before. There were no clues for her that this was a hazardous condition and that the defendants created this hazardous condition. So we ask that you affirm the Court of Appeals decision. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. One of the things that's been discussed at length in the Appellee's presentation is this issue of concealment. And one of the problems with the recitation of the facts that we just heard, and this is in the Court of Appeals opinion, is it says, this is Mrs. Cullen's own testimony, record on appeal, page 437. So there's nothing that would have prevented you from seeing the insulation sitting on top of the drywall here. Correct. I did not see it. That's what Appellee's counsel cited. That's what the Court of Appeals cited. The very next question says, but there wouldn't, I'm just saying there's nothing that prevented you from seeing it. I mean, it wasn't blocked. It wasn't hidden. No. That's the issue. This hole was not concealed. If you look at page, and I can pull it up here one moment, the photograph that's contained in the Appellee's brief, it doesn't actually have a record on appeal site for it, but this is it. You can see the insulation. This insulation is jagged and of different heights, different colors, different lengths. It stands out differently from the attic above. It stands out differently from the plywood. It stands out differently from the blown insulation. The next picture that is also helpful is contained in the record on appeal at page 247, contained in our brief here. This is a photo of the attic. There is danger lurking everywhere in this photograph. This is not a place where it is reasonable to walk backwards without looking where you're stepping. You could trip on a truss and fall down. You could trip on a box and fall down. You could trip on this HVAC and fall down. This is a place where a plaintiff, to exercise ordinary care for their own safety, needs to be prudent about looking where they're stepping. The other issue that I want to just briefly address is about this hole posing a safety hazard. The Logan developers people absolutely testified this hole is a safety hazard, but they also testified that this hole was required by the North Carolina Building Code. And so while they could have done all of those things that plaintiffs' experts suggested they should have, those are issues of negligence. They're not issues of conscious and intentional and reckless disregard, deliberate misconduct. Keeping that hole open because they think the building inspector requires them to have that hole open does not rise to the level of gross negligence that's been set forth by this court repeatedly. And the last thing I want to leave this court with is page 7 of the reply brief that we submitted on behalf of Logan developers. And it contains the 3 pages and the exact quotes from Mrs. Cullen. Record on appeal, page 45. As I was taking the pictures, I took a step back and fell through the opening. Record on appeal, page 439. I backed into it, yes. That's the only thing we can figure out. Record on appeal, page 437. So I, just took a step back, and that's how I think it happened. It is only now in the Court of Appeals and at the Supreme Court that plaintiff argues that that testimony should not be believed. Her own words are what should decide the outcome of this case, and her own words reflect a failure to look down in a dangerous environment. Unless I have any other questions, I would ask that you reverse the Court of Appeals opinion, and I thank you very much for your time and consideration.
Thank you, counsel. Thank you to both. Court.